Question 976. A listing broker enters into a verbal agreement to share his commission if a buyer can be found for a property. However, when the cooperating broker subsequently procured a buyer, the listing broker declined to split the commission. In response, the cooperating broker may A. Ask the district attorney to prosecute the listing broker, B. Not recover his share in court because this was only a verbal agreement, C. Recover his share in court, D. None of the above. Correct answer is C. Recover his share in court. While real estate listing agreements themselves must be in writing to be enforceable, due to the statute of frauds, agreements between brokers to share commissions are generally not subject to the statute of frauds. Therefore, a verbal agreement between brokers to split a commission is typically enforceable. The cooperating broker can sue the listing broker to recover the agreed-upon share. Question 977. The Truth in Lending Act, TILA, is part of the A. Federal Consumer Credit Protection Act, B. Regulation ZC Federal Housing Act, D. The Fannie Mae Charter. Correct answer is A. Federal Consumer Credit Protection Act. The Federal Housing Act deals with housing and urban development. Fannie Mae's charter defines its role in the secondary mortgage market. The Truth in Lending Act, TILA, is Title I of the Consumer Credit Protection Act, CCPA. It is a federal law enacted in 1968 protecting consumers in their dealings with lenders and creditors. This act is designed to promote the informed use of consumer credit by requiring disclosures about its terms and cost. While Regulation Z implements TILA, it's the implementation of the act, not the act itself. Question 978. The one benefiting the most from a subordination clause in a trust deed is the A. Trustee, B. Beneficiary, C. Mortgagee, D. Truster. Correct answer is D. Truster. A subordination clause in a trust deed, or mortgage, allows a later loan to take priority over the existing loan. The truster, borrower, benefits most because it allows them to obtain new financing, like a construction loan or a second mortgage, that will have a higher lien priority than their original loan. This is crucial for things like development or refinancing. The trustee is a neutral third party who holds the title to the property until the loan is paid off. They don't directly benefit from the subordination clause. The beneficiary, lender, is agreeing to a lower lien position, which increases their risk. They are not the primary beneficiary of the clause itself. Mortgagee is synonymous with beneficiary, lender. The subordination clause is primarily for the benefit of the truster who wants to obtain new financing that would otherwise be difficult or impossible to secure with a lower lien position. Question 979. John, a potential home buyer, asks a broker to find a suitable loan for him. The broker will probably contact A. A local appraiser, B. A bank, C. Fannie Mae, D. The Federal Reserve Bank. Correct answer is B. A bank. An appraiser is hired to determine the value of a property, which is part of the loan process, but the broker wouldn't contact them to find a loan. The lender usually orders the appraisal. Fannie Mae, Federal National Mortgage Association, is part of the secondary mortgage market. They buy mortgages from lenders, but they don't originate loans directly to borrowers. The Federal Reserve is the central bank of the United States. They regulate banks and influence monetary policy. They don't make loans directly to consumers for home purchases. A broker assisting a buyer in finding a loan would typically contact lending institutions like banks, credit unions, or mortgage companies. These are the entities that directly originate loans to borrowers. Question 980. A lease can be terminated by A. Mutual consent of the parties, B. An offer to pay higher rent from a different tenant, C. The arrest and conviction of the tenant for unlawful activities on the premises, D. Both A and C. Correct answer is D. Both A and C. A landlord cannot terminate an existing lease simply because they receive a better offer from someone else. A lease is a binding contract for a specific term. A lease is a contract. It can be terminated by mutual agreement between the landlord and the tenant. This is often done through a written agreement called a surrender. If a tenant engages in illegal activities on the property and is convicted, the landlord typically has grounds to terminate the lease. This is often specified in lease agreements as a cause for termination. Question 981. The duties of an industrial property manager likely do not include the following: A. Verifying the operation of the fire alarm system. B. Composing the lease agreements. C. Hiring security guards. D. Maintaining the building's landscaping. Correct answer is B. Composing the lease agreements. An industrial property manager is involved in the leasing process, showing the property, negotiating terms, etc. The composition or drafting of the actual lease agreements is typically handled by legal counsel, lawyers. The property manager might use standard lease forms and fill in the blanks, but they generally don't create entirely new lease documents from scratch due to the legal complexities involved. The other options are common duties of an industrial property manager. A. Verifying the operation of the fire alarm system. This is part of ensuring safety and compliance with building codes. C. Hiring security guards. Security is a major concern for industrial properties, so managing security personnel is a common responsibility. D. Maintaining the building's landscaping. Maintaining the grounds is part of overall property maintenance. Question 982. Which of the following is not an example of voluntary alienation of property? A. Gift. B. Will. C. Sale. D. Forfeiture. Correct answer is D. Forfeiture. Voluntary alienation means the transfer of property is done willingly by the owner. Forfeiture, on the other hand, is an involuntary transfer of property. It occurs when an owner loses their property due to a breach of a condition in a contract, like the land contract, or due to legal action, like condemnation or tax foreclosure. The owner does not willingly transfer the property, it is taken from them due to their actions or legal proceedings. Question 983. The types of consent that can be given are: A. Express. B. Statutory. C. Implied. D. Both A and C. Correct answer is D. Both A and C. Express consent is consent that is clearly and explicitly stated, either verbally or in writing. For example, signing a contract or verbally agreeing to a service. Implied consent is consent that is not explicitly stated but is inferred from a person's actions or the circumstances. For example, if someone sits in a barber's chair, it's implied that they consent to a haircut. Statutory consent isn't a recognized form of consent in the same way express and implied are. Statutes, laws, may require consent for certain actions, but the consent itself is either express or implied. For example, a law might require express consent for medical procedures, but the consent itself is still express, a signed form. Therefore, while statutes can govern consent, they don't define a type of consent. Question 984. A franchise may be sold by A. Real estate licensee. B. Securities licensee. C. Person registered for that purchase with the California Corporations Commissioner. D. Any of the above. Correct answer is D. Any of the above. The sale of a franchise can involve different types of licenses or registrations depending on the specific nature of the transaction and the jurisdiction. A real estate broker's license in California authorizes the sale of business opportunities. A franchise is often considered a type of business opportunity, especially if it involves the transfer of an existing business with goodwill, assets, or real property. Therefore, a real estate licensee can sell a franchise under this authorization. Generally, the sale of a typical franchise is not considered the sale of a security. In most cases, a typical franchise agreement isn't considered a security. However, it could be deemed one under rare and specific circumstances. This occurs if the agreement is structured so the franchisee is a passive investor, relying entirely on the efforts of the franchisor or other parties. In such a case, a securities license would be required. This is uncommon for most standard franchises. The California Franchise Investment Law regulates the offer and sale of franchises in the state. This law is administered by the California Department of Financial Protection and Innovation, DFPI, which was previously known as the Department of Corporations and is often referred to by that historical name in some materials. Franchisors must register their offers, and individuals or entities acting as franchise sellers or franchise brokers. This registration is specifically for selling franchises. Therefore, the most comprehensive answer is D, any of the above. Question 985. An EER measures a property's A. Electricity effectiveness rate, B. Energy efficiency ratio, C. Escalating energy report, D. None of the above. Correct answer is B. Energy efficiency ratio. EER stands for Energy Efficiency Ratio. It's a measure of the cooling efficiency of an air conditioner or heat pump. It's calculated by dividing the cooling output, in BTUs, by the power input, in watts. A higher EER indicates greater energy efficiency.